Good evening, everyone, and thank you for joining us for the third in our series of our family education nights for the 2022-2023 school year. We're really excited to have you. My name is Kristen Parson, and I am the IEP liaison for Northstar's Career Center. And I'd also like to introduce Holly Peel, who is on the call. She is the director of the Career Center. At the Career Center, we work with junior seniors and young adults with disabilities to help them build their career readiness skills so that they can use those as they transition out of secondary education and enter the workforce. You can learn more about Northstar's Career Center on the Northstar website. There's a Career Center tab, or you can reach out directly to us over email, and I'll be sure to include those links in the chat here for you in just a minute. We are also very happy to have attorney Matt Bellinger with us from Bennett Counsel. And Bennett Counsel is a legal firm that assists families of individuals with disabilities with legal and financial planning. They work with families on everything from guardianships to applying for disability benefits to special needs estate planning. So tonight he's going to be giving us an overview of those decisions and processes. So without further ado, I'm going to turn it over to Matt and turn my camera off. But remember that you can always put any of the questions that you have in the chat.
Thanks, Kristen. So little about myself. I'm a 1986 graduate of the Naval Academy. I chose Marine Corps as my service selection. I was a Marine Corps infantry officer. Got out of the service, worked for a logistics company for 12 years, and then decided that I was going to go to law school. So I'm a 2008 graduate at the University of Richmond, and was doing mortgage-backed securities in 2008. That's round zero of the recession. So found myself out of work, and one day I was trying to figure out Medicaid waiver services for my daughter who's on the autism spectrum. And I threw my pen down and thought to myself, you'd have to do this full time. Quit your job and do this full time to figure it out. And then I realized I didn't have a job to quit. So that was kind of the idea behind starting Bennett Counsel. We work solely with adult children with disabilities and their families. And my daughter is a proud graduate of Northstar Career Center and Northstar Academy. And she's doing really well. Purpose of our talk today is that I remember as a parent, you spend so much time when your children are in middle school and high school learning IEPs, therapies, all sorts of things to help your child in the moment. And then they turn 16, 17, 18, and you start hearing about all the things that have to change and all things that you have to do. And it's a whole new world out there. There's a lot of different things that you have to try to learn. And it's really not possible to become the subject matter experts as parents in the kind of the things that we're going to be talking about today. And that's why I do what I do. So what we're really going to be focusing on is what happens when your son or daughter turns 18. I'm going to go through, I'm going to loosely follow this PowerPoint presentation, but you'll notice I'll deviate and sometimes I'll just keep talking on a slide. But really what happens is that under Virginia law and the law of most states, 18 is the year of majority. And so the decision-making rights that you have as your son or daughter's parents transfers to them when they turn 18. And they're presumed by law to have the capacity to make their own decisions, even if they can't or even if they need help. And they're likely become eligible for disability benefits. Prior to the age of 18, we'll talk more about SSI and the requirements there, but they're likely not eligible for SSI because your income and assets are deemed to be theirs. And when they turn 18, parental deeming of income and assets ends. So they likely become eligible for benefits. And then you also need to start perhaps thinking about special needs trust for them. So those are the kind of things that we'll be talking about today. With the decision making, the first thing you notice when your child turns 18 is likely going to be on the medical side. You try to make an appointment for your son or daughter, and the doctor says, I see that your son, is 18 now. I need to talk to your son to schedule the appointment. And you'd be like, what? But I'm his parent. I've always done this for him. So Yeah, you'll see it on the medical side. You'll see it on education side. As part of IEP meetings, teams are supposed to talk about the capacity issues when your son or daughter turns 18. And I think it's supposed to come up like a 17-year-old IEP meetings, their junior year or whatever year that may correspond to when they're 17. And so things change a little bit. And so let's talk about capacity first. So when we're talking about capacity, we're really talking about the ability to take in information and to use that information to make a decision, to evaluate it, to look at the pros and cons, the consequences, and make a decision. It's not really necessarily talking about bad decisions. It's absolutely possible for somebody to have legal capacity to make decisions and make bad decisions. I have made bad decisions that I regret. So we're really talking about the capacity to evaluate it sufficiently. And I bring that up only because it's in the Virginia Code, and that poor judgment alone is not considered to be sufficient evidence of incapacity to make decisions. It's harder then to take this definition and turn it around and say, how does that apply to my son or daughter? Well, actually, I'm going to skip this and go over to the powers of alternatives first. So when I meet with parents, and the first thing I look to do is learn more about their son or daughter. And I'm looking to see if their son or daughter has the capacity to sign a power of attorney or an advance directive. These are documents that a person could sign when they turn 18 that would appoint agents. They're very much like the documents that elderly persons sign or adults sign as part of their estate planning. You appoint agents to do things on your behalf, and so that you don't have to. And there's a durable general power of attorney that if your son or daughter has the capacity to sign that, that would allow you to sign off on their Medicaid waiver service applications and their services. It would be allows you to help manage their finances. There's a medical power of attorney or an advance directive, as they're called in Virginia, which they appoint you as their agent to help make medical decisions, to make medical appointments, to fill prescriptions, to act as their agent and do those things. There's also a power of attorney for education, which would be for IEP meetings. Fortunately, it doesn't extend into post high school years, but it's very helpful for IEP meetings and the like. So these are documents that sometimes a young man or woman can sign when they turn 18 that kind of maintains the status quo of allowing their parents to continue to help make decisions and do things on their behalf. Now, the capacity to sign that's required to sign these documents, and it's a legal question. It's up to the attorney that drafts them and that's working with you. Is that your son or daughter would have to be able to understand the power that he or she is giving you. Not necessarily have to read the document all the way through, not be able to explain what's a power of attorney or what's an advance directive, but to understand the authority. And since I solely work with adult children with disabilities and their families, I like to find that capacity whenever I can. Sometimes it's sufficient for me to be talking with a young man or woman, ask them, do you want your mom and dad to continue to help make decisions? Or who do you want to help make decisions? And they say mom, or they point to mom and dad. And I think in a lot of cases, they don't really understand what's going on at that point, because I think the natural reaction is like, of course I want mom and dad to do it. That's what mom and dads are for. So they don't necessarily understand that we're talking about agency but they understand that if they sign this document, that allows mom and dad to continue to help them make decisions. And sometimes that's enough. So that's the first thing I look for. Second, though, is even though sometimes a young man or woman may have the capacity to sign a power of attorney and advance directive, it may not be enough. So somebody that has really complex medical challenges that needs surgery, sometimes that surgery is out of state. Well, we'll often look at it and decide perhaps a guardianship would be better, and we'll talk about that. Sometimes behavioral challenges are present and such that we want to do a guardianship to protect the young man or woman in case they get into trouble, so that there's already a judicial adjudication that they don't have the capacity to make their own decisions. It's usually on the medical side, though, that we would lean towards doing a guardianship instead of a power of attorney and advance directive. And I'll give you another example of that after we've talked about a guardianship, because I think it'll help you understand the interplay between the two. So again, alternatives is the first thing we look for to see if those will work. And if they will work, then that's likely the best choice for your child, because they don't take away any rights. They don't take away your child's right to make their own decision. They allow you to help them as little or as much as possible. And with my daughter, we have advance directive and power of attorney for her. When she was 18, my wife made most of her medical decisions. Now she's 24, and my daughter makes most of her own medical appointments. And so there's still times, though, where my daughter will say, "Mom, I don't feel comfortable. Can you make this appointment for me?" And my wife will, of course, do that then. So guardianship. So guardianship is something that we would consider then if the young man or woman doesn't have the capacity to sign a power of attorney and advance directive. If they're nonverbal and they can't explain their understanding of the documents, or if there's complex medical issues or behavioral challenges. So guardianship is a procedure in the local circuit court. It starts when you file a petition asking a judge to appoint guardians for a person. Now, the process is the same no matter if you're 18 or 85. And much of the statute, in my opinion, is written with elderly persons in mind. And so you can ask the court to appoint more than one guardian, so there can be co-guardians. So both parents can be co-guardians at the same time. You can also ask the judge to appoint a standby guardian. That's somebody that does nothing while the guardians are living, but will step into their shoes if something happens to them. If you have somebody that you immediately comes to mind for a standby guardian, that's great. If not, then that's something that can always be added at a later date. As part of the process, the court appoints a guardian ad litem. Guardian ad litem is another attorney that's trained to work with adults that are allegedly incapacitated. And the guardian ad litem's job is to be a neutral third party, to represent the young man or woman's or the person's best interest, because they're likely not able to represent their own interests. And that's why the guardian ad litem is appointed. Guardian ad litem will meet with everyone, meet with the young man or woman, and then report back to the judge whether he or she needs a guardian and whether the proposed guardians are suitable. And in cases where it's parents for a soon-to-be adult child, it's really straightforward, and the answers are obviously yes and yes. But it's an important part of the process to have the guardian ad litem appointed, because otherwise there would only be one party. And in our legal system, we rely on at least two parties to be able to, a complainant and a respondent, the Commonwealth and the defendant, and those kind of things, because you got to get both sides of the story that way. Guardian ad litem helps the judge to make a better decision. And then in a guardianship process, after the judge signs the order and you've met with probate to be sworn in, you would have all the legal authority then to continue making decisions for your adult son or daughter after they turn 18. As part of the guardianship process, though, they'll lose the rights to make their own decisions, specifically the rights to make their own medical decisions, decisions on where to live, and educational decisions, because if they can make those kinds of decisions, they don't need a guardian. They'll also lose some other rights: the right to own a firearm, the right to sign contracts, the right to marry without the guardian's approval, the right to drive, and the right to vote. Although those last two, the right to drive and the right to vote, I can often get a judge to allow a young man or woman to retain those rights, especially if they can exercise them. If so, right to drive, sometimes we try that and the judges will say no, because they're sometimes can be a little conservative, and they'll say, well, nobody thinks that it's a good idea right now, and it never is. At that point when they're turning 18, in these cases where I try to retain the right to drive, they don't have their learner's permit, and it's questionable whether they will be able to drive many times, but we try to retain it just so that it's an aspirational thing, or it may be important to the young man or woman. Sometimes the judges will say no, but the point being here that I'm building to is that you can always restore rights. Rights can be restored. It's not permanent. A guardianship doesn't have to be permanent. The rights can be restored individually, or all of a person's rights can be restored. I helped a young woman in Danville restore all of her rights. When she was 18, her mom got a guardianship over her, but by the time she was 28 and I met her, then she was making her own doctor's appointments. She was making her own medical decisions. She was getting to and from work on her own. She was working part-time. And so we put on a lot of evidence for the judge to reassure the judge that, first of all, she had the capacity to make her own decisions. And second, that she wasn't going to be just on her own after he signed the order restoring her rights. So the first thing we did after the judge signed the order is that I had her sign a power of attorney and an advance directive appointing her grandmother as her agent to do things on her behalf. And so that's kind of a little bit of the interplay between guardianships and powers of attorney. In most cases, it's an either or, but so sometimes you can start with a power of attorney and advance directive, and then if they're not working, go to a guardianship. It doesn't happen to me too often that way, because what I've found is that if a young man or woman has the capacity to sign a power of attorney and advance directive, and we decide to go that route, they continue to develop at their own pace. And as every year goes by, the need for a guardianship becomes less and less, and to the point where it's like, yeah, it's really not something we would want to consider, because they, like I said, they continue to develop at their own pace. They're still learning how to do things, and they continue to develop even in their 20s. My daughter's 24 and she's still learning new things. So often, though, that's why if we do a power of attorney and advance directive, my experience is that works, and we don't have to come back and revisit it to do a guardianship at a later date. So guardians make decisions over the person, so to speak. It's medical, educational, and where to live and living arrangements. It's not finances. That's a conservatorship. It's the same process as a guardianship. So you would think that it makes sense to do them both at the same time, but it doesn't for a couple of reasons. And I don't do very many conservatorships. First is that the young man or woman typically doesn't have any assets. It's not like they've been working their entire life and they have a large estate that needs to be managed. Second is that, and we'll talk more about SSI in a bit here, but when they become eligible for SSI, you can become their representative payee. Social Security Administration does not use conservatorships or guardianships or powers of attorney. They recognize them, but what they do instead is they use their representative payee program for beneficiaries that don't have the capacity or ability to manage their own finances. So, but as representative payee, the check would come in your name for your son or daughter's benefit. You would use the letter from the Social Security Administration appointing you as their representative payee to open up an account in your name for their benefit. It's a type of custodial account. And the checks would be direct deposited into that account, and you'd have control over your son or daughter's disability benefits, which is likely going to be a large part of their income for a while. But you'd have control of it without a conservatorship. And so finally, the last reason not to do a conservatorship, and this maybe I should start with, is that it comes with reportings to the Commissioner of Accounts. Those reportings can be those reportings can go every 3 years. The fees can be reduced. Sometimes the commissioner of accounts will waive them, but at the same time, it's just a pain in the butt. It's like being in endless probate. And it just doesn't make sense to do a conservatorship if you don't need it to add those reports in and fees. So the only time I do conservatorships is when a person that relies on SSI, Medicaid, and Medicaid waiver services, because they all have a $2,000 countable resource limit, and gets a direct inheritance or gets money from a settlement, and we have to do a conservatorship to have the legal authority to move the money into a trust. But we'll talk about that later because it's better to avoid that in the first place. So I think the next slide might be questions. I'm going to check the chat to see if there's any questions about guardianship or not any so far. It's okay. If you do have questions, feel free to add them later because we can always do it after the recording is done. And after you've had time to think about things a little bit more. So we talked about guardianship and the alternatives and powers of attorney, advanced directives. The other thing, and another thing that happens when your son or daughter turns 18 is they likely become eligible for SSI, supplemental security income. We'll talk about that. We'll also talk about two different disability benefits, SSDI and childhood disability benefits, to give you a little bit of an idea how your child's benefits will change over the years. They'll morph, so to speak. And we'll also talk about the healthcare benefits, Medicare and Medicaid. Now, a lot of this is informational because it's not necessarily something you have to worry about now, but I think that the more times you hear it and you're thinking about it down the road, maybe it'll have planted a seed and you'll recognize what's going on, or you'll be thinking about it when the times come. So supplemental security income, SSI, is a disability benefit, is meant for persons that are disabled or blind or over the age of 65 that have low income and low assets. The asset limit here is the easiest one to learn. It's hard limit, $2,000 accountable resources. And the reason why most children are not eligible for SSI is when they're under the age of 18, parents' income and assets are deemed to be theirs. But when they turn 18, parental deeming of income and assets ends. So after your son or daughter turns 18, then that's the time to apply for SSI on their behalf. The income limit is usually not an issue for my clients, the young men and women that I think are my ultimate clients, because they don't have an income. But the income limit is actually not necessarily 1470, but that's the best number to use because the definition of a person with a disability that's used by the Social Security Administration is someone that is not capable of performing substantial gainful activity. Not meaning that they can't work at all, it's just they can't perform substantial gainful activity. And I've said it twice and I've kind of emphasized the words because SGA, or substantial gainful activity, is a defined concept, defined term by the Social Security Administration. And one definition of SGA is whether or not you make more than $1,470 a month. And that's the 2023 number. If you make more than $1,470 a month, you are not disabled, no matter how disabled you are. That's I think probably the most important income limit as far as eligibility for SSI. The maximum benefit is $914 a month in 2023, and it's meant to pay for room and board. So if your son or daughter is living with you and they are not paying their fair share, and that's what the Social Security Administration calls it, their fair share, they'll lose 1/3 of their SSI because that's considered to be a type of unearned income called in-kind support and maintenance. And so they'd lose a third of their benefit. But if you charge your son or daughter room and board, then they'll get their full benefit. And that room and board payment to you from their account to your account each month is the largest drain on their representative payee account, keeping it under $2,000 in countable resources. Because that $2,000 countable resource limit applies to the account that their disability benefit goes into. So the way to figure out how much to charge for room and board is to add up all your housing expenses plus food for the month. So mortgage or rent, gas, electric, if you're paying for water and sewer, plus food, divide by the number of people living in your home, and that's your son or daughter's fair share. That number is typically somewhere between $600 to $800 a month. If it's over $914 a month, then it's likely that your son or daughter can't get their full benefit, because even $1 of in-kind support and maintenance is enough to trigger the 1/3 reduction rule. So remember, when you're figuring that number out, their fair share, to use an average over the course of the year, because gas and electric changes based on whether it's summer or winter. I'll finish up on that. So the way it works as far as charging room and board, once your son or daughter has been approved, that's the time that you'll want to tell the Social Security Administration that you're charging room and board. It's often enough to tell them you're going to be charging room and board, and here's the amount, and that's how I figured it out. And sometimes that'll be enough to have them change it in the system. Sometimes the Social Security Administration will ask for more information. They may even ask to see your mortgage or your rent statement or something along those lines, or how you figured out all the numbers. Give them whatever they ask for, but don't necessarily volunteer information. Just whatever they ask for to be able to get it changed in the system is what you should do. Now, I kind of skipped over the SSI, how to apply for it. So there's couple ways. One is that you can do it online. If you Google apply for disability benefits and you go to the ssa.gov website, you can do it basically straight through their website. It'll give you a code so that you can come back in and complete the application at a later date, so you don't have to do it all in one sitting. The other ways to do it are to call your local office and to make an appointment. They'll either make it in person, but most of them I think are still doing over the phone. If you do over the phone, I would recommend that you have all the information that you need ready to go, so that, because basically what's happening is when you do it over the phone, the person from the Social Security Administration is completing the application in the system on their end with the information you're providing. So that if you have the information, it makes that go a lot more smoothly. And their website will tell you, give you a rundown of the amount of information that they need. So we're talking about SSI still, and I'm looking at the slide, and it goes on into work incentives. Hi, Holly.
Hi, we had a really good question in the chat, and I just wanted to address it. One of the participants asks, do you need to have citizenship to receive SSI? The question concerns her son, who is a legal immigrant, so he has legal resident status here.
Yes, I think legal residence status should be sufficient. You need a Social Security number. So assuming that their son or daughter has that, then I think, I'm not sure, I'm not certain though. That would be the first time I've had to answer that question, and I would need to look it up for sure. I would recommend that perhaps they can contact me afterwards, because I'd want to make sure. I want to make sure.
And I found a resource document, so I'm going to link that in the chat as well.
Okay,
Thanks.
perfect. So we talked about applying for SSI. We talked about what it's for. We talked about charging room and board. I want to also talk about how earned income affects SSI. Earned income, so money that your son or daughter is making, because they're at the Career Center. and they're gonna be working eventually. That's wonderful. Their earned income will reduce their SSI, but it's not a dollar for dollar basis. And the point I would like to leave you with for sure on this subject is that your son or daughter will always make more money working, even though that it reduces their SSI, because it doesn't do it for dollar basis. The first $20 is there's a general income exclusion. The first next $65 they make is there's an earned income exclusion. And if there are no other work incentives that apply, the Social Security Administration takes the remainder of their income for the month and divides by 2. And that's how much SSI your son or daughter would lose. So again, they would always make more money working than, even though that they lose some SSI. And I think I have a slide that shows it. And I'll show that now. I'm going to skip to it and come back. So this is SSI only. And this is SSI and part-time work. You can see that SSI is reduced, but that part-time work, and these are actual numbers I put in. So this isn't me just kind of doing something that just to show a diagram to make it look good. So always make more money working. Now you have to report earnings though. That's important because if you don't, when we report the earnings for a particular month, Social Security Administration uses that information to calculate your son or daughter's SSI benefit for 2 months out. And if you don't, they won't catch it right away. They'll continue on paying the whole $914 a month, $914 a month, $914 a month. But at the end of the year, they get a dump from the IRS that says, here's all the income for these people. And the systems merge, and you will get a letter stating that your son or daughter was not eligible for benefits for these months because, and they'll adjust it. Or not necessarily not eligible, but they weren't eligible for a full benefit. And here's how we figured out how much. And they'll say, this is how much your son or daughter owes back. And they always get it wrong. And it invariably you get that letter. And then the next letter you get is like 2 weeks later, 3 weeks, and saying, oh, we miscalculated. Here's a check, sometimes even. And then you get another letter says, oh, we miscalculated. And by that time, I can't figure it out anymore. And you end up just doing with whatever, paying back whatever money the Social Security Administration seems to arbitrarily set their mind to how much the overpayment was. And so the point being is that when your son or daughter starts to work, report the income to the Social Security Administration. There's a couple ways to do it. There's an online way. You can call it in. You can send in the pay stubs. Whichever works best for you, but report that income because you don't want to get into a overpayment situation. It's just a pain in the butt. So the other benefits I wanted to talk about are Social Security disability insurance. It's a really similar acronym, SSI, SSDI, but it's completely different. SSI is a type of welfare. It's paid for by the general federal budget. It's kind of at the whim of our politicians. SSDI is a Social Security benefit, and it's a benefit that becomes eligible, your son or daughter may become eligible for as they work, because it doesn't take a whole lot of work to be able to get the credits that your son or daughter needs to start becoming eligible for SSDI off of their own work record. Those credits, the amount of credits a person needs changed based on how long you've been working in your age. I think mine might be like 40 credits. It'd be really large, and within the last 10 years. But for a young man or woman, when they're starting out, just even sometimes like 3 to 4 years, 4.5 years of even marginal part-time work will eventually get them the credits they need to start getting SSDI off of their own work record. That change from well, it's not necessarily a change, but when they become eligible for SSI, what happens to their, for SSDI, what happens to their SSI is the SSDI reduces their SSI on a dollar for dollar basis. Because for SSI, it's considered to be unearned income. So they don't end up getting any more benefits. But the more they work, the more the SSDI they get, the less SSI. And that's kind of what I was showing here, is that This is the point where your son or daughter is still getting some SSI. It's reduced now because they've got more SSDI here. And this is their earned income. And the more they work, the more this blue line will increase and the more the SSI will go down. And that's not a bad thing. SSDI has a dedicated funding stream with our payroll taxes. It's harder for our politicians to make the change because there's lots and lots of people when get Social Security that would be up in arms if they make changes that are not defensible. Let's put it that way. But the other thing, when they become eligible for SSDI, they'll also become eligible for Medicare. We'll talk about that in a little bit. So there's a third disability benefit that many young men and women become eligible for during their lifetime, and that's the childhood disability benefit. It's really misnamed because they don't get it when they're a child. They get it when a parent passes away, when a parent retires and starts drawing Social Security, or when a parent becomes disabled and starts drawing SSDI. The child could become eligible for a benefit off of the parent's work record. And it's for adult children that were found to be disabled before the age of 22 that are still unmarried. So if you retire when you hit 65 and your child is 35 at that time and they've been getting SSDI or SSI their entire life, they become eligible for childhood disability benefit. And it's off of your work record. The amount of the benefit they get depends on your work record. For the parents for the children that I have that are clients that get childhood disability benefit, it's in the $1,400 to $1,800 range, and it probably has gone up because every year with the increases to the Social Security benefits. So it's quite substantial. And what happens at that time is it wipes their SSI out. That's fine. There are work incentives in place, or they're not work incentives, but there are parts of the statute that allows them to retain their Medicaid waiver services, even though they don't have SSI. So childhood disability benefit's a pretty good benefit. It's also more commonly referred to as SSDI off of a parent's work record. I think that's not necessarily accurate either, but that's what it's called. It's referred to as that. You'll get more when you hits in Google. If you Google that, then if you try childhood disability benefit, if you do childhood disability benefit, you Google that term, you really got to get down into the weeds and find references to the program operating manual that actually refer to it as that. So I'm kind of going off on a tangent. Sorry, lots of coffee. But when they become eligible for childhood disability benefit, this is what their benefits would look like. If they're working at this time, then that's great. Their work does not reduce this benefit. And if they're not working, then they would get this portion of it. Because I understand that many young men and women with disabilities may not be able to work, and this might be what they get. They get SSI, parent retires and starts drawing Social Security. They get the SSDI off of the parent's work record. So I'm going to skip the questions because I'm going to go right into Medicaid. And I think there's some in the chat, but I wanted to get to this first too. So Medicaid is kind of the partner to SSI. It's also meant to help pay for medical care for persons that are disabled, blind, or over the age of 65. It's a joint federal and state program, but it's administered by the states. Income limits vary by state, and usually the issue with Medicaid is not the income limit, can be, but it's the countable resource limit. Again, hard $2,000 accountable resources. So as you're managing your child's accounts, the representative payee accounts and their earned income if they have, remember that you need to keep them under $2,000 accountable resources. When your son or daughter becomes eligible for SSI, they'll become eligible for Medicaid as well. Some of you may have children that are already eligible for Medicaid, and that's because if they're getting actual services through Medicaid waiver services as a child, you get Medicaid on the back end of that. And again, there's Medicare. So Medicare, Medicaid, they sound so much different. Medicaid is a type of welfare paid through by states and the general federal budget goes with SSI. Medicare is paid through by our payroll taxes, and it's more commonly, you can consider it as a kind of a companion to Social Security. The way your child can get Medicare is that when they get when they get SSDI off of their own work record after 2 years, they become eligible for Medicare. That's one way. Another way is when you retire and they become eligible for that SSDI off of your work record, they become eligible for Medicare. That's a common way as well. Medicare is good insurance. All of our seniors rely on it. And if your child happens to become eligible for Medicare and you're still carrying them on your private insurance, that's the time to think about dropping them off of your private insurance. So they can stay on your private insurance until they turn 26 by law. I'm surprised at how many medical plans will allow a parent to continue to carry a child with a disability on their medical plan past the age of 26. So you might want to check as your child is getting close to 26. Might want to check to see if you can still carry them on your personal or employer provided insurance. The hierarchy of payments, though, it's always going to be private insurance first, Medicare, and then Medicaid. So the clients that I have that are dual eligible for Medicare and Medicaid hardly ever use their Medicaid. It's the Medicare that they use. So I'm going to go to questions on that, and let's see what we have in the chat box. What is the difference between SSI and your child being on the DD waitlist? Okay, so one thing I didn't cover in this is Medicaid waiver services. Those are home and community-based services that help young men and women or persons with a disability live and work in the community as independently as possible. One of the things, now they're called waiver services. One of the things that are waived is that parental deeming of income and assets. And that's how, when you apply for Medicaid waiver services and your son or daughter is still a child. And that's how, first of all, they can get on the waiting list. And that's also if they start getting the services in their child, that's how they get Medicaid. If you were to apply for the Medicaid directly, your income and assets are deemed to be theirs, but because they get the Medicaid waiver services and are actually receiving the services, that's how they get Medicaid on the back end. So SSI and Medicaid waiver services, the DD waiver list, are actually two separate benefits. SSI is more of a cash benefit each month, and Medicaid waiver services, DD waiver, there's different waiver services like the CCC Plus and the CL, but those waiver services, those are actually like attendant care and respite care and transportation. That's a separate part of a separate benefit. So think of them as independent of each other. The way to apply for Medicaid waiver services, if you haven't, is through your local community service board. If you haven't already, I would recommend that you do so. I would urge you to do so. To get on the waiting list, the DD waiver waiting list can take years to come off of. And there's several priorities, 3, 2, and 1. But your son or daughter, first of all, will eventually come off the waiting list. Second, as their situation changes, they could come off the waiver list much more quickly. I've even seen persons who have a parent who's passed away and they're on the waiting list, get the services right away, the community service board, and they get with the FAP team and they get emergency services and they get them started right away. So it's important to have that application in. Again, it's your local community service board for that. Let's see, I had another chat question. It was above that. Oops. If you apply for SSI and it takes a few months to get paid, how do you avoid your account going over $2,000 if that first check is for multiple months? Good question. So you will get a back payment. It usually takes the Social Security Administration about 3 or 4 months to come to a determination. And when your son or daughter is found eligible, the Social Security Administration will send you a payment for those 3 or 4 months it took them, from the date you applied to the date of the first check, or those months. And that can be over $2,000. By regulation, you have 9 months to spend that money down. So it shouldn't count as a resource for 9 months. However, my advice is to not give the Social Security Administration a chance to make a mistake. I have one client who did that. They said, oh, your son or daughter wasn't eligible for these months because they were over the $2,000 countable resource limit. We submitted the appeal and said, oh, that's because they got the back pay, and then we never heard anything back. So I think that solved it. And there was no more questions from them. So my advice actually on that is to open an ABLE account for your son or daughter. Or first of all, you can spend the money. You can spend it down on things for your son or daughter to get it under the countable resource limit. And you can do that over 9 months, and you're perfectly within your rights to do so that way, to manage the funds that way. But the other option is to open an ABLE account. And I'm jumping ahead to the next part, but that's good because this is all kind of flows together. ABLE account is a 529A account. It's very much like a 529B college savings fund. You can contribute money to it up to $17,000 now in 2023 each year. Money in an ABLE account can be invested, and it grows tax-free so long as it's used for a qualified disability expense, which is pretty much anything for your son or daughter. And it does not count as a resource for SSI, Medicaid, and Medicaid waiver services. So it's a great place to put your son or daughter's money that they may be earning through earned income, or money that they may be getting from their disability benefit, or combination of both, to keep them under the $2,000 countable resource limit. Now, it's not necessarily a great place for your money, though. It sounds like a great opportunity, but ABLE accounts have payback clauses, meaning any money in an ABLE account, when the beneficiary passes, has to go back to the state to reimburse it for Medicaid expenses. Now, state of Virginia says they're not going to do that. They passed a law a couple of years ago that says they're not going to do that to the extent federal law allows. Well, thanks a lot. Thanks a lot. Because federal law still requires it. And I don't know, I haven't heard of any push to get rid of that requirement. So here's the best guess as to what would happen. If your son or daughter's ABLE account, when they pass many, many, many years from now, has $5,000, $6,000, $8,000, $9,000, $12,000 in it, my guess is the state will not try to get that money. It's not going to be worth their while. But if it has $90,000 in it, because it can have up to $100,000 in it and not count as a resource, it has a lot of money in it. I think the state will find it kind of very convenient. Like, oh, federal law still requires this, so we need to get that money. So it's a great place for your son or daughter's money. You can save their money then. It's a super savings account for them. That the money then can be used later and for larger purchases, furniture. There's a whole list of things that the money can be spent for your son or daughter. The way to start an ABLE account is through ABLE Now. That's Virginia. That's who runs Virginia's ABLE accounts, ablenow.com. And they're good accounts. But that would be my recommendation. Long answer for a very good question about what do you do with the back pay that your son or daughter gets. What are the rules on withdrawal from an ABLE account? I would recommend that you address those questions to ablenow.com. But generally, you can use them for any of your child's expenses, even room and board, if you need to. So it's quite a flexible account. If you move money from a child's ABLE account to the ABLE account, is it legal and not send any type of red flag? Oh yeah, it's absolutely legal. In fact, I often recommend clients use ABLE accounts. So say, for example, a young man or woman gets $10,000 inheritance from a long lost uncle, direct inheritance, and I get a panic call from parents going, "Oh my God, they're going to lose their benefits. What do we do?" Well, I said, it's easy. Open an ABLE account, put the money in the ABLE account. And the reason that it's actually perfectly legal is it's for the benefit of your son or daughter. You would report it when you get those annual questionnaires from Medicaid or SSI or Social Security Administration that they have the account, and so they would know about it. And that's exactly what it's for, is for your son or daughter's money. I mean, well, you can put money in it too, but it's money in there does not count as a resource, and that is a perfectly acceptable use of their money. Put it in there. If all these benefits are rejected, elect citizens, is there any legal services available? The citizenship questions that I am not as familiar with as far as disability benefits. Okay, so that's something I think we should, I would prefer to address separately, so I have time to review it. My guess is that there's not a whole lot of recourse. SI, DD wait list, if it takes a few months. Great questions. All right. So talked about guardianship, alternatives of guardianship, powers of attorney, advanced directives. Talked about SSI, SSDI, and SSDI off of your work record. And we've talked about Medicaid and Medicare. So the segue into the next section is a reminder that SSI, Medicaid, and Medicaid waiver services have a hard $2,000 accountable resource limit. So I urge you to watch that closely. What's accountable resource? Well, anything that is cash or cash-like. So it really includes gift cards and things like that. Although I don't know how the Social Security Administration or Department of Medical Assistance Services know about those, but anything that's cash or cash-like. So you need to keep your son or daughter's accounts under 2,000. So I usually recommend that you just have a representative payee account. That's for the SSI benefit. If you have multiple accounts, like if you have a checking account form or a savings account form, you certainly can, but you have to remember to add up the totals of all the accounts at each month so that they don't go over $2,000 in countable resources. My fear is that you'll forget that there's $400 in the savings account, and there'll be a period of time for several months where no matter, you're watching the representative payee account diligently, but the total of the accounts is over 2,000. Social Security Administration will not catch it right away. They don't watch things that closely. What happens is several years after the fact, they pull all of your son or daughter's account information, and I envision somebody in a dark room someplace in the lower part of one of their Social Security Administration buildings in the basement with a stack of reports, probably all electronic, but I envision it with a stack of folders, and they're just with a highlighter going over 2,000, over 2,000, over 2,000. And this is, so it's in 2023. Somebody's right now doing it, and they're on the West Coast because it's still during working hours. And they're looking at somebody's returns for 2020 or 2021 or 2022 right now. And they're just over the limit, over the limit, over the limit. And you'll get a letter saying that your son or daughter was not eligible for disability benefit those months because they were over the countable resource limit. And there's nothing we can do. You can ask for a waiver of that, but there is not, you can appeal it, but you'll lose because it's a hard limit. So now that I've beaten that horse, I'm not beating anything or any horse. Now that I have talked about that ad nauseum, that's a better way to put it. Talk about special needs trust, third-party special needs trust. So the purpose of a third-party special needs trust is so that you can leave your son or daughter an inheritance without messing up their eligibility for SSI, Medicaid, and Medicaid waiver services. Because money in a third-party trust does not count as a resource for those benefits. And the reason it doesn't is because it's not actually your son or daughter's. It's not theirs. It's the trust. And the son or daughter is the beneficiary, is the sole beneficiary of the trust. They get the benefits of the money in the trust, but it's not their money. And so what the third-party trust does while you're living is it sits as an empty bucket, waiting to be filled when you pass through your wills and beneficiary designations on things like life insurance and IRAs, 401ks, and brokerage accounts and so forth. When I work with clients to do a third-party trust, I give them instructions basically to open up a checking account, put $100 in it, keep the account open, and that's where it sits. It stays that way for a while. And we have a trust for my daughter, and my life insurance and my beneficiary designation and IRA, also brokerage account, and my will say everything to my wife. But if she's no longer living, then half to my son who's typically developing and half to my daughter's trust, not to her directly, but into her trust. So it never becomes a accountable resource. Then the successor trustees of the trust will use that money to pay for things that my daughter's benefits and income aren't paying for, to supplement her quality of life. And in a way, then it replaces me, gives me some, I don't want to say, it relieves anxiety that I have over what's going to happen to my daughter. From a financial standpoint, I know that there'll be money there to use for her benefit. And then many years from now, when she passes away, it would go to her kids if she has kids. But if she doesn't, then it would go to her brother and her brother's family. So the thing with the third-party special needs trust, when you create it, the money in the trust then goes to whomever you say it does when the beneficiary passes. There's no payback clause. It doesn't go to the state to reimburse it for Medicaid expenses or anything like that. So that's what I use. That's what is used to be able to allow you to leave an inheritance to your son or daughter for their benefit without messing up their benefits. The way it kind of plays in with the ABLE account. So ABLE account is more for your son or daughter's money because it has that payback clause. Their money can't go into a third-party trust because if it does, and your son or daughter's money then it doesn't have a Medicaid lien. There's no lien on it, but that's the way I think of it, is that your son or daughter's money, when they pass, is supposed to Medicaid, it may try to get that money. If you put their money into a third-party trust, it defeats the purpose of a third-party trust. So think of it more along the lines of your son or daughter's money has special rules that go with it. It either goes into an ABLE account or a first-party trust. You don't want to do those. We don't need to talk about them. But your money and everybody else's money in the family can go into a third-party trust. And so if you have, your son or daughter has grandparents or aunts or uncles that want to leave them money as part of their estate planning, they can do so. So my daughter's grandparents, my parents-in-law, before they passed, they wanted to leave all of their grandchildren money. So we asked them to change their estate planning and point my daughter's inheritance to her trust instead. So now it's got like 30,000 in it, and my wife and I are just investing that money for later use. We're still alive. We're still supporting her and helping her out. And then that money will be there for her later after we pass. So other family members can leave money to a third-party trust as well. And I think I am hitting 6 o'clock on the money. Let's see what kind of questions we have. Okay, these are more SSI questions. So good. I'm going to go into that. So can you speak more to the SSI amount? If there are only 2 people in the house, expenses will be more than SSI the child receives. How does that work? Okay, so I think that's a question about when I was talking about charging for room and board. You add up all your housing expenses and divide by the number of people living in your house, and that's your child's fair share. Unfortunately, if that number is over $914 a month, the Social Security Administration person you talk to is likely going to tell you that they're not eligible for the entire benefit, the whole benefit. They'll keep them with that 1/3 reduction. So it's something like $610 now, I think it is. And that's just an unfortunate way that the rules are written. There is a section in the program operating manual system that gives you an alternative way of charge room and board. by comparing market rates for rental of a room and a use of a bathroom in your house. I've tried that a few times and it got absolutely nowhere with the Social Security Administration, unfortunately. So see what the other questions are here. That's an S&T question. I think there was another SSI one, requirements. SSI amount, oh, that's it. Record keeping for use of the recipient's money, like room and board and other expenses. So another SSI question. Right now, the Social Security Administration is not requiring parents who are representative payees for their children to do detailed accountings. What they have is an annual form they send you and ask you generally, how are you spending your child's money? And now the answer is, I'm spending it on room and board and clothing and doctor's copays and the like. The list is what you're spending it on. Now, is it possible that they'll come back and ask at some future date or change that and ask for parents to do detailed accounting? Yes. So my recommendation are these. So on that representative payee account, get a debit card and charge everything that you need to onto that account directly. You can reimburse yourself for expenses that you paid yourself for your son or daughter, but I don't recommend doing so, because to me that is something where somebody is sitting with a felt tip pen in a dark room would see, is like, oh, what was this for? And it may have been perfect. You bought shoes from Payless and you forgot the debit card, so you paid for it and then you reimbursed yourself. Well, if you do so, keep good accounts. Just keep a copy of the receipt. That way you can show what it was for. But it's better to have the charge, in my opinion, go directly to that representative payee account. I do recommend that you keep receipts then for all the money that you spend out of the representative payee account. Just keep them in a folder. You don't have to create a detailed spreadsheet or anything. And here's my thinking on that, is that since you don't have to do a detailed accounting now, if they ever change it in the future, you're in the habit of having all the receipts. If they ever do it and you weren't aware of it, well, you've got all the bank statements and you got receipts and you can line up. So when you're looking at the bank statement, you see something from March 17th, 2022, and you're like, what was that $24.75 for? And you're like, oh yeah, Payless, here's the receipt, boom, got it. So that's what I would do, is just keep the receipts, throw them in an envelope. As far as room and board goes, if you are your son or daughter's representative payee, every month when the check comes in, if you're charging them $750 for room and board, then you would you could write yourself a check, put a little note on it, it's for, January room and board, or you can do a transfer from their account to your account for that. I'd recommend that you do it for the amount. If you told the Social Security Administration that you're charging $750, do the $750 every month. And then it's easy, because that'll also make it easy for the Social Security Administration, that person in the dark room with the highlighter would see, oh, rent is $750. All right, $750, $750, $750, $750. Okay, I get it. That makes sense. So that's how I recommend doing it. That probably gathered some more, but I think there might have been another line. Red flag, able account rules. All right. Room and board. Okay. What is the best way to set up a trust, and who manages the trust? So when I write a third-party trust, lawyers write third-party trusts. When my wife and I, before I was even an attorney, we met with a broker, investment advisor, who talked about special needs trusts for our daughters and talked about all these things and gave us a big thing to fill out. And then we were like, well, who do you write the trust then? And it's like, oh no, you'd have to get an attorney. Well, how much does that cost? And it's $3,000 or $4,000. And at that point we were like, oh my gosh, the anxiety went up. We set it aside, didn't touch it for years. And I saw that folder. Every time I saw it, I would get anxiety, like, oh my God, I need to be doing something with it. But attorneys write trusts. My flat fee for a third-party trust is $500, because I think every family that needs that has a child that has a disability that relies on means tested benefits needs one. So it's something that attorneys write with you, and you can have a lot of say in what goes into the trust, as far as what happens to the money, who are the successor trustees. And the trusts I write, I start with the parents as the original trustees. So There was another chat. It was after that. This. So the trustees manage the trust, and after it's funded, it would be the successor trustee. But who handles the special needs trust? So this is my son, and you go to the bank lawyer. While you were living, when you're trustees of a special needs trust, it's not funded until you pass typically. So there's not a whole lot you need to do. The burden of managing the trust falls more to your successor trustees. And for those successor trustees, I would recommend first that they hire an accountant to do the trust taxes. It's not hard to do them. I'm doing it for my daughter. I use TurboTax. You have to get the business edition for it to do trust. It's not hard, but they don't need to worry about it. They can hire an accountant using the trust assets. Hire a legal assistant, just somebody that, if I'm still alive, they could talk to me or any other attorney if they have questions about whether or not something may be a good expenditure for the trust. Use a broker if there's a considerable amount of money in there. We have got, my wife and I use Wells Fargo advisors, but there's lots of brokers and they can advise the trustee on how to invest the money. So it doesn't have to be all of that. They have to do it themselves. And I think by explaining that to your successor trustees, that might help alleviate some issue of the anxiety that they may have or worries they may have. I think so. Last on trust is that the trust is a legal entity. It's not a company, but it's like a company. It's not a person, but it's like a person. It is a separate legal entity. It comes into existence as soon as you sign the trust agreement. It will have its own tax identification number that will eventually be used to pay its own taxes and do its own tax returns. So it's a legal entity that can own any investment vehicle that a person can own. So it can own stocks, bonds, mutual funds, CDs, bank accounts, checking accounts. It generates income just like a person does, and it pays taxes on the income that it generates. However, a trust will also have a tax deduction for the income that it uses for your benefit of the beneficiary. So it can get to a point where if working with an accountant and a broker and trying to figure out how much money is necessary to maintain the young man or woman who's the beneficiary, where the trust pays no taxes. And I would love to do that kind of work, but that's really not legal work. So, so I bring that point up is so that you don't necessarily worry about, oh my gosh, the trust has to pay taxes. Well, yeah, it does. It's a legal entity that generates capital gains or regular income or dividend income. It pays taxes on that, but it doesn't have to be substantial. The other thing to point out about special needs trust, because I have a few minutes, I was told to try to go to 6:15-ish, that'd be good, is that trusts can own real estate. They can own cars. So a trust, your son or daughter's special needs trust can own a car that's used for their benefit, even if your son or daughter doesn't drive. And the purpose of perhaps the trust owning it is that maybe it's used for their benefit. And that way the trust owns it, but somebody else drives it. The trustee is responsible for, maintaining insurance and repairs and things like that. It can own real estate though too. So sometimes when you get to the final questions that you have to answer, after you work through all these things, what you're left with is still work. And for your son or daughter, what are they going to do perhaps for work? And that's a journey of its own. And what are their long-term living arrangements? And sometimes their long-term living arrangements might be something like the trust owning a condo where they live, or the trust owning the home they live in. And so they can live in there with Medicaid waiver services, with attendant care and things like that. Now we're talking about people that your son or daughter will continue to develop for a very long time, into their 30s even. My daughter, I anticipate my daughter will still be learning new things. And it may become at some point where they can live independently with help, somewhat independently. Or it may be that your home is perfectly suited for them to continue living after you pass and you want to leave your home to them. So we moved into the Berg Park area, Richmond, so my daughter could be closer to public transportation and job opportunities. And we haven't done it yet, but one of our ideas is we could leave our home to our daughter's special needs trust so she can continue to live there with support. And the benefit of having the trust own real estate for those kind of arrangements is that, first of all, home ownership is I remember when we were new homeowners and our water heater broke and we were like, Dad, what do I do? So having the trustee there to manage those kind of things is beneficial. The trust then pays for the taxes, the trust pays for insurance. The trustee can have somebody come in and clean the home once a month, because that's often something that our sons and daughters don't do very well. And you maintain the property, get the grass cut, but all of that really falls on the trustee, who's much better suited to do those kind of things than her son or daughter with a disability. I'll check. I got 2 more chats that come up, see if there's a new one. So do we elect the trustee, or so? Yes, in the trust agreements, when you create the trust, you'll decide who the successor trustees are. And it's often a succession of people if you have that many people in your family. So you think right away, if something happens to me right now and it's funded, well, it could be a grandparent. Or it could be young men or women's aunts and uncles, your brothers and sisters. And eventually you want to have a successor trustee that's from a younger generation, because our sons and daughters are likely going to outlive us. And so one of the things, if you don't have that person right away, that's fine. You can always add them. You can amend the trust to add a successor trustee pretty much at any time. Not participants, chat. I think there was another one. So how does a special needs trust if your state doesn't offer one? The trusts I'm talking about have nothing to do with the states. I write trusts for people. It's an agreement that we create, and we create the entity. I get the tax ID number, and there are attorneys all over the state that are doing special needs trusts and trusts for people just the same way. They don't have to be third-party trusts, don't have to be recorded with the state. They don't have to be reported to the Commissioner of Accounts. No, it's an agreement that lawyers create that is governed by what's in the trust agreement. I think that answers that question. Okay, I think that's it. And if anybody else has any questions after the recording ends, we can go over those. I'll stay on the line. And Kristen, do you want to take over and stop the recording, or I'll leave the share up?
Sure.
Thank you so much. Your presentation was amazing as usual. I learn something every year, and my brain always feels like it's swelling after this presentation. I got one question in the chat. This is so much information. Is there a way we can go over it again? Yes, of course. And please know, first of all, that most of our families feel that way the first time they go through this information. This is dense information. Everyone who participated will receive an email with links to the information. It will also be posted on Northstar's Transition to Adulthood website. So Matt, I just wanted to thank you for your time and your expertise, so generously being with us and supporting us one more time.